Justice Jackson made an interesting point, but not the one I think she intended.
In that situation, I guess I'm struggling to see how it burdens a parent's religious exercise if the school teaches something that the parent disagrees with. You have a choice. You don't have to send your kid to that school. You can put them in another situation. You can homeschool them. How is it a burden on the parent if they have the option to send their kids elsewhere?
Talk about living in an ivory tower. Justice Jackson acts as if sending your child to a private school or homeschooling them is a simple matter. Apparently, she doesn't realize what's involved in either of those choices.
Well, Your Honor, the world we live in this case is that most parents don't have that option. They have two working parents. They can't afford to send a private school.
Absolutely.
And that's the reality for our parents.
I understand, but in so many other constitutional doctrines, we don't focus on whether people actually can afford to protect their rights.
What's odd to me is that nowhere else is the right to protect your religious freedom from government infringement based on whether or not you can afford to do so. This court has repeatedly stated that you cannot be deprived of a public benefit because of your religious beliefs. But according to Justice Jackson, public school is different.
And what I guess I'm worried about is a world in which when there is an option to send your kids somewhere else, it seems to me that these parents would be dictating what this school does in the way that you say our cases say they can't do.
Tell me, Justice Jackson, will the parents who left Montgomery County schools because of their opt-out policy be reimbursed for the taxes they've already paid to support that school? See, it's not merely whether or not they can afford other options. They have been taxed under threat of fines and jail to pay for these schools. Justice Alito got into a similar discussion with Mr. Schoenfeld.
So you have a case where some of the plaintiffs are devout Muslims. They say, we have a solemn religious obligation to raise our children as Muslims, and that involves certain moral principles that we want to instill in our children, and this school is teaching our children moral principles that are in conflict with ours, and we pay taxes to support the public schools, but we don't have enough money to send our children to private schools, and one of us can't stay home and provide homeschooling. So we just want to be able to take our children out of the part of the instruction that we find objectionable. And what's your response to that? Your response to that is just, well, it's too bad, all right? This is the public school, and the public school can teach what the public school wants, and you don't like that, well, you can send your children to private schools.
There's no indifference to the religious beliefs of the petitioners in this case. The school did what it could to accommodate those views. There are simply circumstances in which what the petitioner or what any plaintiff recognizes as a burden on their religious belief is not a legally cognizable one, given legal and practical justice.
Well, except the board never mentioned the administration of the opt-out until the lawsuit. And the main complaint regarding administration of the opt-outs is the number of people opting out. Does that sound like respect for the parents' religious beliefs? Not to Justice Alito.
Well, it's nice that you say that they respect the parents' religious beliefs, but basically your answer is it's just too bad.
I think my answer...
You've got to send your children to school. You can't afford to send them to any place except a public school, unlike, most of the lawyers who argue cases here. They can send their children to private schools. We may think that that's the way most of the world is, but it's not. It's just too bad.
My answer is that public schools are democratically controlled for a reason. The school board here is democratically elected. The entire process of adopting this curriculum is open and transparent. These books are on review for 30 days before they're even made part of the curriculum. There's then a multi-level appeal process. There's plenty of opportunity for parental insight.
Except neither the United States nor the state of Maryland are democracies. They are constitutional republics. And this is a perfect example of why we are not a democracy. See, democracies allow the majority to overrule the rights of the minority. Simply because the majority of the people of Montgomery County chose board members who wish to promote a sexual agenda on children as young as 3 years old does not deprive their parents of the right of public benefit without compromising their religious beliefs. As Mr. Baxter pointed out in his rebuttal, this was hardly a democratic process.
This was not a democratic process, withdrawing these overnight. comparing parents to xenophobes and white supremacists. This can't be part of the democratic process.
Under Maryland law, parents are compelled to send their children to public schools unless they ask for an exemption. And now, when everyone else, religious or otherwise, is allowed to benefit from these schools, Justice Jackson and the Montgomery County Board of Education wants to bar the door, just as George Wallace did with the University of Alabama in 1963, simply because their religion does not promote this sexualization of children. How can that not be a burden on the free exercise of religion?